Can I ask you a question, Mr. Jacoby? I'm having a hard time tracking exactly what the government's position is, so I asked Ms. Blatt, explain to me how these defenses that you're proposing fit within the contract analogy. And I don't know, I sense some going back and forth about whether the contract analogy is a perfect fit so that all these defenses are available, and if so, I'm not really sure how the miscarriage of justice backline position fits in unless we try to shoehorn it through public policy. So explain to me what the government's theory is here.
Sure. So petitioner has litigated this as a contract doctrines case, saying that all these contract defenses apply. Our position is if we're going on contract defenses, no, none of them applies.
Well, let me ask you that just as a matter of first principles. Is it the government's position that this should be litigated as a contract case?
I do think so, and I think that there's not really another source of law that petitioner has identified to lodge this miscarriage of justice exception. It's not contract principles.
No. The government, like, do you think of this? Do you think the petitioner is right to litigate this? Because you've gone along with it, and you've said if we're talking about contracts, it doesn't work. But do you think of this challenge as something to which the contract analogy should apply?
I do think that this type of argument is one to which the contract analogy should apply. There's no constitutional right to an appeal, so I don't think it makes sense to say that there is a constitutional right to an appeal in certain egregious cases. So the Constitution isn't really a home for this doctrine. And other than that, I think you would just be engaging in some kind of federal common law policy making where Congress hasn't.
So is the position, can I just finish this one? So is your position that the contract analogy applies, but none of the contract defenses work in this context?
Correct.
Okay. So when you're making this concession about, potential miscarriage of justice, et cetera, you're just kind of pulling that from the ether?
So there we're assuming that you are kind of going outside of contract doctrines and you are trying to find as some sort of policy or maybe constitutional backstop some safety valve. And we think if you were going down that road, the safety valve I proposed to Justice Kagan is the right one. But again, we do not think that that is the right way to go.
Well, why isn't Justice Gorsuch right then? I mean, are we supposed to march through every single available contract defense from the restatement and say, this is why this couldn't apply here, this is why that couldn't apply here?
Petitioner has come up with 4 potential defenses. None of them applies. I think that you can just categorically say.
As to his case, but we're not.
No. Categorically, when a subsequent sentence does not make an appeal waiver against public policy, it doesn't make it unconscionable, it doesn't make it a breach of the implied duty of good faith, it doesn't frustrate the shared purpose that goes to the essence of the bargain. Just categorically, those defenses all fail. If there are other defenses out there, it was on petitioner to raise them, and he hasn't.
Is the
Didn't argue that. Sorry. Justice Kagan.
Is the premise of your answers to Justice Barrett that this court has no power to establish rules intended to safeguard the integrity of the judiciary?
That is not our position, but the rules need to be lodged, I think, in some source of law. There's no congressional source of law. There's no really constitutional source of law, given that there is not a constitutional right to appeal. So I don't think it makes sense.